President. I rise to speak on behalf of the Coalition in relation to this bill and indicate at the outset that we will be supporting it. Domestic violence is such an important issue in our society that any sensible measures to engage with it should receive bipartisan support. And in that spirit, we will be supporting this legislation. The provisions of this bill have been well outlined in the Minister's second reading speech, and I have no intention of rehearsing the detail. We welcome the improved definition of stalking, which will better capture the way in which technology is used to stalk and intimidate domestic partners. We also welcome the provisions which will allow, in limited circumstances, sole parents to change a child's name without the other parent's knowledge or consent. These changes, if and when they are implemented, will make a difference to the protection of the vulnerable in our state. This bill has been described by the government as another part of their legislative program to address domestic violence. But what a disappointing program that has been. Or rather, they have been active in producing legislation, but disappointingly seem to lack any program to actually ensure that this legislation commences and is implemented to foster safety for women. This government has made announcement after announcement, has put up bill after bill, but shows absolutely no commitment, or indeed appears not to have any concrete plan to actually put their words into action and make real changes to protect the vulnerable. And again, they present us with another bill covering very important subject matter, but without a commencement date for the totality of the bill, other than the never never of proclamation at some time in the future. It is as if this Attorney-General and this government, rather than claiming to be an Austinian positivist or a Scalia originalist, is a Gilbert and Sullivan Cocoist. When Coco has to explain to the Mikado why Nanki Poo, whose execution had been ordered and reported, is still actually alive, Coco says, "It's like this. When Your Majesty says, 'Let a thing be done,' it's as good as done, practically. It is done, because Your Majesty's will is law. Your Majesty says, 'Kill a gentleman,' and a gentleman is told off to be killed. Consequently, that gentleman is as good as dead. Practically, he is dead. And if he is dead, why not say so?" And the Mikado replies, "I see. Nothing could possibly be more satisfactory." Are we to believe that when this Attorney-General introduces a bill or this government enacts legislation, that it's as good as done and no implementation is required? Well, unfortunately for this government and for the women of New South Wales, we don't live in the land of musical theatre. We live in the real world, and we expect the government to govern. We are looking for more than words. We are looking for implementation and follow-through. We are looking for action to protect women. The action that we have not seen in relation to the bail and other legislation amendment to Domestic Violence Act of 2024. This Act, passed by this House on the anniversary of D-Day this year, was sadly not the springboard for the sort of positive action we saw 60 years earlier. This Act, the government's direct response to the sad circumstances of the death of Molly Ticehurst, made three main changes designed to protect women. It tightened the bail threshold, it mandated electronic monitoring for those accused of serious domestic violence but who are granted bail, and it required bail decisions to be made by magistrates rather than registrars. However, only one of those three key changes has been introduced: the changes to the bail threshold. We are still waiting for the implementation of the other changes. This bill will assist with that task. It will amend the earlier legislation so that first instance bail matters may be heard by audio-visual link rather than in person. It also requires any accused granted bail, subject to electronic monitoring, must be first fitted with that electronic monitoring before release. We welcome these changes, which will hopefully expedite the proclamation and operation of the earlier Act. However, the fact that the bail legislation needs to be fixed by this legislation only 4 months after its introduction is a clear indication that this government is not thinking carefully about this critically important issue of women's safety. They are not doing the work to get it right, but delaying implementation until they can perform running repairs so that their laws are fit for purpose. Women facing domestic violence deserve the respect of this government. Respect which means that we think about the issues properly and get the legislation right the first time so it can operate promptly. These changes are even more perplexing when considered against the background of testimony at budget estimates. We asked the Police Minister, we asked the Minister for Corrections, we asked the Minister for Women, and we asked the Attorney General what was happening about the implementation of the bail legislation. We heard lots of buck passing to other ministers. We heard about working groups, task forces, Cabinet Office oversight, maybe September, maybe October. But not once did we hear that the bail legislation changes could not commence fully until they were fixed by the Act that we have before us. This leaves us with three possibilities. The first is that the Attorney General was unaware of the problems in his own legislation which needed to be fixed before it could be proclaimed. The second is that he was aware but was unwilling to disclose this at estimates as a reason for the delay in introducing measures to protect women's safety. And the third possibility is the most frightening of all, that no one in this government actually realised that these problems existed until we started asking about the delay in implementation. Not one of these options gives the women of New South Wales confidence that they are being respected and that their safety is a priority for this government. And this government stands condemned by its own impotence. The more we look at this program of the government, the more that we see that it is held together by sticky tape and chewing gum and can hardly be regarded as a serious attempt to address one of the most important social issues of our time. The bill before us makes an important statement about the seriousness of breach of ADVOs and creates two new aggravated offences, each with a much higher penalty. We all know that the ADVO is not necessarily protective. It is a sobering statistic that 22.5% of all intimate partner homicides from 2021 to 2023 were committed with an ADVO in place. But we support any attempt to make them work better and be treated more seriously. And this includes the introduction of the new sections 14.1a and 14.1c. We all hope that stronger penalties send a stronger message to those who might otherwise be tempted to domestic violence. Because a penalty, no matter how high, awarded after an assault or after death is hardly an indicator of success. But to be educative, these higher penalties must be awarded and must be seen to be on the table, which is why it is surprising that these new aggravated offences have both been created as Table 2 offences, which means that unless the prosecutor elects to proceed by way of indictment, they will be heard in the local court where the maximum penalty is not the 3 years of the new 14.1a, not the 5 years of the new 14.1c, but the existing 2-year maximum. The government did a very similar thing in relation to knife crime in June last year, doubling penalties but leaving matters to be tried summarily in the local court. And the outcome? In over a year of this legislation being in effect, there has been not one single case in which the higher penalties have even been sought, let alone awarded. The Attorney General in budget estimates and in repeated press releases stated that this legislation about knife crime sends an important message. What message is being sent if the penalties are never sought or never awarded? Or does the Attorney General believe that possible offenders are scanning his press releases for new laws and moderating their behaviour accordingly? The Boxar stats suggest that they are not, with a sad rise in homicide by knife since the introduction of these laws. It appears that the Gilbert and Sullivan theory of jurisprudence, where the emperor says a thing and is it as good as happens, doesn't in fact work in the real world after all. And so we view with hope but considerable trepidation the prospect that these new offences will in fact have a moderating effect on domestic violence, especially since they have been structured in such a way to make it unlikely that the new higher penalties will ever be awarded. The last major reform introduced by this bill is the introduction of a civil protection order scheme for serious domestic abuse. These orders are modelled on serious crime prevention orders, and unlike ADVOs, can operate prospectively, positively, and address the behaviour of the person of concern rather than being targeted at the protection of a particular person at risk of abuse. In fact, novelly, they can be made for the protection of future partners, not in existence or contemplation at the time the order is made. There are critics of the serious crime prevention orders, just as we anticipate there will be critics of these orders from the perspective of infringement of civil liberties. But if they are effective to protect the personal safety of women and children, that may be a price worth paying. There is certainly evidence of the success of the serious crime prevention orders, but this is not simply because of the order being made. It is because of the way in which these orders have been resourced. Will we see a domestic violence version of Strikeforce Raptor ready to enforce these orders? And if we don't have comparable resourcing, if the law isn't implemented rather than simply being made, how confident can we be that women will be protected? Let us all hope that this measure will in fact be properly resourced and will work. But when we see that breach of these orders is also a Table 1 offence, where unless a decision is made to proceed by way of indictment, the maximum penalty will be 2 years, not the legislated 5, it is increasingly hard to maintain this hope. I worry that women are being gaslit by this government, told they will be safe, told these laws will protect them. But then, as we saw with the bail laws, these laws not actually ever being implemented. Just like Jack's Law, promises, but not a single purchase order for a single wand. And when will the promised changes by this legislation commence? We don't know. It's by proclamation. Well, this is simply not good enough. New South Wales women deserve more. We deserve respect and an end to this gaslighting and fanciful jurisprudence that passing a law is the same as implementing a law. We need a timeline and a real commitment to resourcing to ensure that this initiative has the best chance of truly protecting women. And that's why I indicate that I will be moving an amendment on behalf of the Coalition to lock in a definite time frame for the commencement of the entirety of this law, which is designed to provide women with the protection that we need.